An injunction is an order from the court in personam directed at a person or a company and is enforceable by the court's contempt power. There are mandatory injunctions or decrees telling a person they must do a certain thing. However, these can be somewhat difficult to enforce, and prohibitive injunctions, orders, informing someone they must not do a certain thing or refrain from doing something, are often easier to enforce. There are various types of injunction: reparative, that are designed to repair; preventative, that are designed to prevent some harm; and then there are structural injunctions, designed to change the structure of an organization, like a school, for example. So what are the 4 factors the courts look at in deciding whether they can issue an injunction instead of, or as well as, damages at law? Well, the first one is success on the merits. The plaintiff must win the case in order to then qualify for an injunction. The second factor is the inadequacy of the legal remedy. If money damages are sufficient to remedy the harm, then an injunction is not necessary. The third factor is the balance of hardships and the comparison of the hardships faced by the plaintiff if the injunction does not issue, and the hardships faced by the defendant if the injunction does issue. And then finally, the courts look at the public policy and the interests of the public before deciding if the injunction will issue or not. Injunctions are not issued for the whole country. They're issued in personam. They're directed, targeted to specific individuals and people, organizations, and so on. Generally, you can't go to jail for contempt of an injunction that you are not aware of. And only the parties to the case, their officers, servants, employees, attorneys, and so on, are liable to be bound by the injunction. A preliminary injunction is often requested before the final injunction can issue, basically because it takes so long for the case to be heard in court and for the final injunction, to the permanent injunction, to be issued by the court. In a preliminary injunction case, the 4 factors are slightly different. The first one has changed quite considerably. All you need to ask, we don't have a final success on the merits, so the first factor is the court looks to see if there's a substantial likelihood of success at the subsequent trial. The second factor is the irreparable harm meanwhile. So if money damages are inadequate to remedy, and if there is an urgency and irreparable harm is taking place, then this is a significant factor in determining whether the preliminary injunction will issue. The third and fourth factors are the same as for the permanent injunction. The court weighs the balance of hardships of each side and looks at the public interests. The plaintiff in a preliminary injunction case is required to provide a security bond, which is used to compensate the defendant if the preliminary injunction is issued in error. Some of the states have adopted a sliding scale test as well as the traditional test. And the sliding scale test is really used when there's a huge imbalance of the hardships, but where the likelihood of success on the merits is merely serious questions on the merits. So this test is used under the traditional test. A preliminary injunction would not be issued unless there was substantial likelihood of success. But under the sliding scale test, if there's a huge potential damage to the plaintiff from the injunction not issuing, then the test is reduced from substantial likelihood to serious questions on the merits. This is a court by court and jurisdiction by jurisdiction determination as to whether the sliding scale test is used, and the Supreme Court of the United States has not decided on this yet. A temporary restraining order, TRO, is essentially a preliminary injunction. While the plaintiff is waiting for the preliminary injunction hearing, there's some urgency and they request a temporary restraining order to maintain the situation until the injunction, the preliminary injunction, issues. TROs are decided pretty much in the same way as preliminary injunctions, using the same 4 factors. Of course, the first one needs to be altered in that you show a substantial likelihood of success in the preliminary injunction hearing. Of course, a security bond is required, like a preliminary injunction. And TROs are normally decided at an adversary hearing where the defendant has a chance to put his case. But if the situation is so urgent and there's not enough time to bring both parties to the court, sometimes these TROs are decided ex parte, with one side, simply the plaintiff, requesting the TRO from the judge. TROs are decided in the same way as preliminary injunctions. Of course, the first factor requires a substantial likelihood of success on the preliminary injunction hearing. A security bond is required. Now, TROs are normally decided at adversary hearings where both the defendant and the plaintiff can be brought before the judge and argue their case. However, in urgent situations where it's not possible to bring both parties before the judge will sometimes hear the case simply from the plaintiff and make a judgment on that in an ex parte situation. This can violate the rights of the defendant to due process, as we will see later, unless an adversary hearing can be heard promptly after the ex parte hearing. TROs, temporary restraining orders, are temporary. In the federal court system, the TRO is limited to 10 days. It can be extended to a further 10 days for showing of good cause. The idea is it's just sufficient time for the court to get together to consider the preliminary injunction. Business days are used only in the calculation, not weekends and holidays, and the TRO can be extended by consent of both parties. Under the state, it really depends on the laws of the state as to how long the TRO can last before a preliminary injunction is required or the TRO expires. Now, when a case is removed from the state to the federal district, what happens to the TRO? Well, it remains in place, but it is governed and then capped by the federal law. So the 10-day plus 10-day rule under federal law applies to TROs removed to the federal courts from the states. When it's impracticable to bring both the parties to the court and there's an emergency situation requiring an immediate ruling, then an ex parte hearing can take place where the judge listens to only one side of the argument. Following this ex parte hearing and the TRO that issues, the enjoined party can then demand an adversary hearing and a motion to dissolve the TRO. Otherwise, this will be a violation of their due process rights. Generally, adversarial hearings are required before a TRO can be issued. Specifically, they are necessary when the TRO has been issued at an ex parte hearing and the enjoined party requests an adversarial hearing. The judge has to provide it. Also, If there's sufficient time to bring both parties before the court, the adversarial hearing is necessary. And in free speech cases, the rights of the speaker cannot be enjoined through a TRO, as this is a violation of the First Amendment's free speech rights and would be considered null and void. So the courts are encouraged to offer an adversarial hearing when restricting free speech. In order to compensate a wrongly enjoined party and prevent frivolous claims, a security bond is required to be posted to the court for non-permanent injunctions. The amount of the bond is amount considered proper by the courts. It doesn't always have to be cash. Other forms of security can be used, and in some courts the injunction is invalid without a bond. Although a strict reading of the federal rules would imply that the security bond was mandatory, the courts interpret this very loosely, and there are at least three interpretations. The first one is that the requirement of the bond is mandatory, but the bond can be very small, like $1 or even less. Second interpretation is that the bond is actually discretionary, does not have to be issued for the injunction to be valid. And the third approach is to look at it as almost mandatory, with certain exceptions, such as public interest, claimants, very poor plaintiffs, and non-commercial cases, and so on. So the courts interpret this very differently. In the federal court, a bond hearing is mandatory, but the amount is open to dispute. The security bond is posted with the court and held there until the permanent injunction is decided and the case is settled. The majority view is that the bond forms a ceiling to claims by the wrongly enjoined defendant, and the defendant cannot claim beyond the bond from the plaintiff if it's later found that the injunction was issued in error and the defendant, the enjoined party, suffered damages beyond the cost of the bond. However, the minority view is that the bond does not form a ceiling, and claims to the party requesting the injunction can go beyond the bond itself. Injunctions can be appealed in both the federal and the state courts. Following the injunction, the enjoined party can request a stay by the trial judge and request a hearing. But generally the injunction takes effect until it is removed at appeal or it's stayed pending appeal. The regular four-prong factors, the four factors are used in determining whether the injunction will be stayed. And of course the first factor needs to look at likelihood that the injunction was issued in error. Some jurisdictions will use the sliding scale test as well as the traditional test. A motions panel hears the motion to appeal the injunction, the motion itself, and they can lift the stay pending appeal. A merits panel considers the merits of the case, and they will reverse an injunction only if they see it as an abuse of discretion of the judge in issuing the injunction in the first place. TROs are not appealable. Well, they are if you consider the preliminary injunction hearing that normally takes place within 10 or 20 days of the TRO to be the appeal itself. Injunctions used to be issued automatically in patent cases. After the courts found an infringer, they would typically issue an injunction preventing further infringement. The legal remedy of damages and royalties was considered inadequate. Then came the BlackBerry case, where the injunction threatened to close down the entire BlackBerry service, and the patent holder was not really a practicing company, but a patent troll. Following that case, there was the next opportunity the Supreme Court had was in looking at the eBay case, and it changed the rules. Essentially, the presumption of inadequacy of the legal remedy was removed, and this means post-eBay the 4 factors are considered. Injunctions are not automatically issued. In patent infringement cases, the courts look at the 4 factors when considering injunctions, and if the plaintiff is not a practicing company, not a competing company, then generally the injunction will not issue in a patent case.